So let me just first of all say thank you very much for attending. If you could possibly go on mute, that would be great. Thank you very much for attending. This is the first presentation organised by the Gibraltar Association of Tax Advisors, which I am the chair, and it's great to see so many people have turned up. We appear, I think, to have every single person who replied and said that they would be coming, which is fantastic. So what we're going to talk about today is something which is a coming issue in Gibraltar. So previously, Gibraltar didn't have any double taxation treaties, now has the DTT with the UK, and we are starting to see, or at least I am certainly in my practice, starting to see information requests being sent to the Commissioner of Income Tax as the competent authority under the UK DTT. So I've seen a lot recently. I think I've seen maybe 15 in the last 6 months. So certainly something that's being sent out from the UK, and the Commissioner generally passes them on. In fact, I'm not aware of any that he hasn't passed on. So I think that we need to, as a jurisdiction, need to have an understanding of what it is that we're asked to do on these information requests, and how we should respond to it. The information requests are not always perfect and sometimes do require pushback. And so we thought it would be a sensible thing to organise a talk for the fiduciaries and the people of Gibraltar with somebody who understands and works regularly with information requests. So we have for you today, we were initially timetabled to have 2 speakers. Unfortunately, one of them is unable to attend. And the lady that is, Harriet Brown of Old Square Tax Chambers, this morning was stuck in a lift. So we're actually very lucky to have her at all. She is a barrister with Old Square Tax Chambers, which in 2022 won the Tax Set of the Year at the Bar Awards, which is something I think they should be very proud of. And she is Jersey and English qualified. She works very closely with me at Hassan's on Gibraltar matters. So she has a broad knowledge of the interaction of UK and the Crown dependencies and overseas territories. So she's seen many of these information requests and is a leading light in how to respond to them. She gave me a thing to read out, which I'll read out. She's an English barrister and Jersey advocate. She has extensive experience in advising on English tax law consequences of offshore and cross-border transactions. So I think that from there, Harriet, you there?
I am, sorry, I couldn't find my cursor.
Right, okay, so I'm going to hand over to Harriet. I know that everybody's very busy. This is quite an extensive topic, and I think you've got 19 slides, which hopefully will enlighten us all. I'm just going to be quiet now. I know that's a rare thing, and I'm going to let you talk. So, Harriet, over to you.
Thank you, Graham. And I have to say, I don't remember Graham ever being that polite about me. So that is fantastic. Thank you so much for attending. I'm absolutely delighted to be your first speaker. And as Graham notes, certainly in Gibraltar, but also more broadly, this is becoming an increasingly interesting and important topic. And one of the interesting points about it, certainly from an English perspective, but I think it gives some context to why we're seeing this influx of information notices now, is that HMRC have previously tended to rely on their very broad domestic information powers. And so they have been known to issue English law or UK or law from some part of the UK requests for information under their Finance Act 2008 Schedule 36 powers outside of the jurisdiction. And those have been upheld, for example, in Jersey in a case called Halrabi. And I am told anecdotally that the reason HMRC have hitherto preferred to use these powers is because when they make an information request under a tier, they have to pay for the photocopy. I don't know if that's true. However, what I'm certainly seeing, not only in Gibraltar, but also in Jersey, in Guernsey, in some of the Caribbean jurisdictions, is that certainly from the UK, information requests are now being made under the international agreements. And so Graham is absolutely right to say that this is something that we all need to be aware of and that we all need to deal with. So going to our first slide, yes, there we go, going to our first slide. This process can be difficult and fraught, particularly if the request is received as a third party, which is of extreme relevance to fiduciaries, for example. And this is because you may well have fiduciary and legal duties to the subject of the request, which don't sit easily with the request from the Domestic Revenue Authority. So in your case, Gibraltar. And what I'm saying there is that you can't simply flip the information over to the commissioner without thinking about whether or not the request is valid, whether or not you have other duties that are inconsistent with you providing the information to be the information requested, and in those circumstances, what you can do and how you can square the circle of those two sort of conflicting duties. The other thing that makes this a fraught process is that the mechanisms that are available to challenge notices can be difficult, have limited remedies, and are usually subject to tight deadlines. In fact, Gibraltar is slightly better than a lot of the other jurisdictions because I think, and Graham will correct me if I'm wrong, you still use a standard judicial review process for reviewing information requests. And I'm going to come on to that in a bit more detail in a moment, so don't worry. But for example, in Jersey, you only have a two-week period after you receive the information notice to appeal it to the courts. So it can be very fraught with difficulties. So in order to discuss how we respond to information requests, what I want to outline is what it is and what it isn't, because on request exchange is quite different to automatic exchange. I then want to look at the basic mechanisms and the two ways in which matters are commonly requested in Gibraltar, which Graham has already mentioned, which is Article 25 of your treaty with the UK, and then under the various network of tiers that you have more broadly. I've got an example, which I'm going to try to show you if I can use screen share at the same time as I am controlling Graham's screen with the slides on it. And then we're going to talk about the response, litigating requests, and how you manage to put yourself in a position where you can respond to a request without risking breaching duties that you have to your client. So that's sort of really where I want to go. And I'm going to be very brief on the first couple of topics that I've mentioned. So what is on request exchange and what isn't it? Now, as you may be aware, generally speaking, there are three separate types of exchange. We have on request exchange, automatic exchange, and spontaneous exchange. What we're worried about today is just on request exchange. Automatic information exchange, such as CRS, under CRS and FATCA, is not devoid of issues, but it is much more straightforward as compared to on request exchange. So I'm not going to talk about that at all today, but I am going to recommend the book on the topic that Graham and I have authored, with what I'm sure is an unbecoming lack of modesty, but we do think it's the best one out there, and we certainly try to make it the best one out there if you are facing an issue with that sort of exchange. So
just to point a note on the book, my bits are the best bit out there.
I knew you couldn't be polite for a whole hour. And you've taken back control of the slides, Graham. I don't know what's happened. There we go. So just a brief word on spontaneous exchange, because from a rights-based perspective, and when I talk about a rights-based perspective, I'm primarily talking about rights under the European Convention on Human Rights, but there are other elements of it as well. Spontaneous exchange is problematic. Gibraltar, you were one of the first places to actually start signing up to this spontaneous exchange. And what happens with spontaneous exchange is that one revenue authority will have a bit of paper, will have something, and it says, oh, well, that looks like, I don't know, Gibraltar may say, that looks like Germany would like to see that. And off they send it to Germany. And the subject of that exchange has no idea it's happened. And to me, that is fraught with issues, but we're not going to talk about those today either. So what we're looking at is just this on-request exchange. An on-request exchange, as we've said, arises in one of two contexts. The UK Gibraltar DTA, Article 25. Now that is based on Article 26 of the OECD model. So the good news is there's some commentary on it. There is some case law on it from other jurisdictions. So it's not a complete unknown. There is some guidance. Wrong one. Sorry, is that me? I feel like I should have started. Oh, there we go. Yes. So starting with Article 1, competent authorities of the territories shall exchange such information as is foreseeably relevant for carrying out the provisions of this agreement or to the administration of enforcement of domestic law concerning taxes of every kind and description imposed on behalf of the territories, insofar as the taxation thereunder is not contrary to the agreement, and the exchange of information is not restricted by Articles 1 and 2. So this is an outlier in terms of DTA provisions, and there are three important things to note about it. It doesn't just apply to information relevant to the DTA, but it applies to any information that's relevant to all types of domestic taxes. So it's broader than the DTA itself is. It's not restricted to taxes which are the subject of the treaty or to individuals and entities that are within the ambit of the treaty. And the main protection for taxpayers, and this again is a good thing, it's the same as it is under tiers, is that the information that of which exchange is sought has to be foreseeably relevant to the administration and enforcement of domestic taxes, primarily. It could be foreseeably relevant to the provisions of the agreement, but that's going to be less common on the whole. There is some protection for confidentiality, and that's set out in subpara 2. I'm not going to sit here and just read legislation at you though, so I will leave you to read that yourself. But what I would say about it is that this is marginally better than the provision of the tier in relation to confidentiality. However, it is, in my view, inadequate, and we've started to see some cases which are giving an indication, most recently Schrems 2 in the European Court, which was actually on automatic exchange of information or relevant to automatic exchange of information. But there is starting to be this recognition that these information exchanges cause problems and are not necessarily compatible with domestic law on secrecy, on confidentiality. So that is interesting. We then get further protection for the taxpayer in sub 3. And this tells us that the provisions of para 1 and 2 shall not be construed to impose on a territory the obligation to carry out administrative measures at variance with the laws and administrative practice of that or the other territory, to supply information which is not obtainable under the laws or in the normal course of the administration of that or the other territory, to supply information which would disclose any trade, business, industrial, commercial or professional secret or trade process, or information the disclosure of which would be contrary to public policy. And then 4, if information is requested by a territory, other territories, the other territory shall use its information gathering measures to obtain the requested information, even though the other territory may not need such information for its own tax purposes. And so to sort of this is where it starts to get interesting, really. We note from 4 that this doesn't mean that a jurisdiction can simply refuse a request if they do not want the information themselves. So this imposes the obligation to collect information that's irrelevant to domestic taxes. So Gibraltar, having a much less, I don't quite know how to put it, extensive tax system than the UK, will frequently get requests where it's not, where, you know, it might be relevant to say SDLT in the UK. Well, that's going to have nothing to do with Gibraltar tax in all probability. It's still covered by the agreement. But what I want to talk about briefly is the protections, and I'm so sorry, there's a spoiler here, are similar to those under tiers. And primarily what we should be interested in is the meaning of foreseeable relevance, because this is what you, as people advising or receiving third-party information requests from your revenue authority need to understand in order to know, well, it's one of the things you need to understand in order to know whether or not there's a relevant or a legal request. So the meaning of foreseeable relevance has been interpreted broadly, and what we have here again usefully is quite a lot of case law on the meaning of foreseeable relevance in the context of the EU Savings Directive. And so that is, for a variety of reasons, likely to be carried over into tiers and this on request exchange. So someone who's been very outspoken about it was A.G. Wathalet, and what he said in Berlioz, he described foreseeable relevance as being that the authority of the requested state must be in a position to answer the question whether the requested information can foreseeably be connected to the assessment of the tax which the requesting authority seeks to make. Now, I would say that was fair enough. The actual court, rather than the Attorney General in his opinion, I think was a little bit less restrictive. And what they said was, the requested authority must nevertheless verify whether the information sought is not devoid of any foreseeable relevance to the investigation being carried out by the requesting authority. That then is very broad, really. And they went on to say, and this is what the requested authority, so in your case, the Gibraltar Revenue, would need to be able to say they had done. The review to be carried out must enable that authority to satisfy itself that the information sought is not devoid of any foreseeable relevance, having regard to the identity of the taxpayer concerned and that of any third party asked to provide the information and to the requirements of the tax investigation concerned. So this gives us, as practitioners, a fundamental difficulty in responding to requests, because one of the first questions that a notice recipient needs to ask is whether the information requested is foreseeably relevant to the tax that the notice identifies as being in point. And it should be remembered that while a plethora of other cases have set a relatively low bar for foreseeable relevance, you still need to be checking whether or not there is any obvious connection between the tax said to be an issue and the information requested. If there isn't, then it isn't a legally sustainable request and it needs to be challenged. Now, you then get a difficulty with the challenge because one of the bases of challenge of a request would be that Graham wants me to move on.
No. I want to ask a question when you finish, when you breathe.
Okay. So one of the questions that we need to ask is whether or not the Revenue in Gibraltar has carried out a review of the request from the requesting jurisdiction that enables it to satisfy itself that the information sought is not devoid of any foreseeable relevance, having regard to the factors mentioned. Now, the difficulty that we have with this is that time and time again, disclosure of the underlying request, and I don't think this has happened in Gibraltar, but it's happened in the Caribbean, it's happened in Jersey, it's even happened in the UK for a request from another jurisdiction. The request of the subject of an information notice for the underlying request from the requesting jurisdiction has almost always been refused. And so finding out whether or not that review has been carried out properly or even at all can pose a challenge. And I will come on to what we do about that. But Graham had a question.
So can I just, so obviously if you're a fiduciary, you could have the easy response of, well, I've had an information request from the commissioner, I'm just gonna reply. And you're saying that there's a duty on the recipient to think about whether it's foreseeably relevant. And it feels like that duty comes from the GDPR regulations. You're not allowed to process information without good reason. Would you say that's correct? There's obligations on
That is definitely correct. If you don't do it, there's a number of duties that you might breach. You might breach your GDPR requirements. You might breach a duty of confidentiality under a contract. You might breach your fiduciary duties. There is a risk that you're in breach of fiduciary duties because if the request isn't being properly made, you shouldn't provide the information.
Right.
It's that simple. What is much less simple is ensuring that you don't, in fact, it is working out whether or not it is a proper request.
Okay.
So what we say there, what I say there is that you need to think about foreseeable relevance, and you need to think about what documents you reasonably require from the Gibraltar Revenue Authority in order to obtain, in order to be able to make that assessment. So it may be that it's quite obvious from the information that it's on point. So it may be that the information notice mentions one taxpayer, it mentions one transaction, and it wants to know if an amount was received into a bank account that is equal to the amount paid to the taxpayer for the transaction. In those circumstances, it's an easy win. Where it gets more difficult, you can see that that's foreseeably relevant. It's clearly relevant. Where it's more difficult is where you have you do get fishing expeditions being made under these sorts of notices. And there, where you've got sort of like a broad number of requests, it might relate to a number of taxpayers or to taxpayers unknown. That's when the foreseeable relevance point becomes more difficult to deal with. But the point is, you need to think about it. You can't just flick the information off. You need to be thinking about what you're doing. So coming then on to exchange under a tax information exchange agreement, this is very broadly similar.
Sorry, Harriet, can I just ask one more question?
No, yes, of course you can.
So let's imagine a situation where Gibraltar has an information request from the UK, and that the tax information that's requested by the UK would also be relevant to Gibraltar tax. Can the Gibraltar authorities use the information that they've received under the information request notice, the Section 6A notice, for their own purposes, or is that like ring fenced off in a separate process?
That is a very good question, Graham. Do you have the answer to it?
No, I don't fully know what that.
I don't. My recollection is that there is no ring fencing, and I think it's a bit like, isn't it? If you waive privilege, once the ketchup's out of the bottle, no one's going to suggest you should try to put it back in. Right. So I'm not aware of any process that would prevent them from doing that. So, and also, because you are using domestic information gathering powers, I would have thought, because it's the application of those powers, it would be very hard to then say, but you can't use it for your own domestic purposes.
Right. Okay. All right. I'll be quiet now, I promise.
No, keep them coming. So just to note here that Gibraltar has a large number now, a relatively large number of information exchange agreements. And I've listed I think it's all of them there, but I've said including just in case it isn't. Delightfully, they're all based on the OECD model. So they're all very similar. And for ease, we're going to look at the OECD model. Doing that. There we go, perfect. So we're now looking, this is Article 1, and if you can mentally compare and contrast with Article 25 of the DTA, it tells us that the competent authorities of the contracting parties shall provide assistance through exchange of information that is foreseeably relevant to the administration and enforcement of the domestic laws of the contracting parties concerning taxes covered by this agreement. Such information shall include information that is foreseeably relevant to the determination, assessment, and collection of such taxes, the recovery and enforcement of tax claims, or the investigation or prosecution of tax matters. Information shall be exchanged in accordance with the provisions of this agreement and shall be treated as confidential in the manner provided in Article 8. The rights and safeguards secured to persons by the law or administrative practice of the requested party remain applicable to the extent that they do not unduly prevent or delay exchange of information. And the relevant point there is delay, because what some of the larger higher tax jurisdictions have complained about is that it takes too long to get things done. And indeed, that's why Jersey has ended up with this very odd sort of appeal stroke review process, because there was a case called APEF management. And because it was taking so long for the appeal process, and bearing in mind that the appeal was by way of judicial review, so it really wasn't taking that long, France threatened to blacklist Jersey unless they speeded things up. So they changed their law. So the rights and safeguards maybe perhaps not what they would be. And the idea of what is undue delay is perhaps not what it should be either. So those are just points to bear in mind going forward. Now, the great thing about your tiers being based on model tiers is that you've got commentary, and the commentary, sometimes problematic, can be helpful. Now, the key points from the commentary on Article 1 are this. It doesn't have to be certain that additional tax will be due when the information is provided, or that the information will be significant in calculating a customer's liabilities. And so what the example that the commentary gives is that information from Gibraltar doesn't need to establish that, may simply establish that no additional tax liabilities exist. So it may just confirm what the Revenue Authority have already been told. I think that's axiomatic, but perhaps helpful to have it set out in full. Less clear-cut, the commentary tells us that information doesn't need to be certain to provide a smoking gun. It simply has to be capable of having an impact on a tax liability. However, you can't have a speculative request for information. And what the commentary says that means is that there must be foreseeable relevance to a particular taxpayer or group of taxpayers. And so the mechanism is found under Article 5. Just to note, unlike CRS, the exchange is bilateral and the agreements are bilateral. So this is very simple. It's one country to another country. So Article 5 tells us that the competent authority of the requested party shall provide upon request information for the purposes referred to in Article 1. Such information shall be exchanged without regard to whether the conduct being investigated would constitute a crime under the laws of the requested party, if such conduct occurred in the requested party. Now, this is a sort of a hangover or a drag over from treaties on things like extradition. And effectively what it's saying is just because this information could be used in criminal proceedings and it wouldn't be criminal in your jurisdiction, you should still give it to us. It's probably not, I hope it's not going to come up that much for all of you. Does someone else have a question? No, okay. And secondly, it says, if the information in the possession of the competent authority of the requested party is not sufficient to enable it to comply with the request, that party shall use all relevant information gathering measures to provide the applicant party with the information requested, notwithstanding that it may not need such information for its own tax purposes. So that's relatively straightforward. It's saying that you need to have, sufficient powers to get information that other countries are going to need. And indeed, that is where you have your sort of 6A, 6B, 6C processes in the Income Tax Act 2010. And so that is relatively straightforward. So the domestic powers that the contracting parties need to have must cover the following things: information held by banks, financial institutions, persons acting in agency or as fiduciaries, and then information regarding the ownership of a whole variety of different types of entity, as well as ownership information on all persons in an ownership chain. In the case of trust, information on settlors, trustees and beneficiaries, and in the case of foundations, information on founders, etc., etc. It then goes on to say, however, that this agreement does not create an obligation to obtain or provide ownership information in relation to publicly traded companies or public collective investment funds or schemes, unless such information can be obtained without giving rise to disproportionate difficulty. I mean, I would have thought the reason that is excluded is because that would almost never be difficult for the requesting authority to find itself. But in any event, that is sort of where it is. So this brings us to the second point that you need to be looking at. You need to check that the information requested is within those domestic provisions for collection of tax, for collection of information. So as I said, sort of 6A, 6C, that area. Now, probably it will be. Such provisions are drafted very widely. see if I can see what yours says. Yours is 6A, I think, isn't it? So what yours says is that the Commissioner may, by notice in writing, require a person to deliver to him information relevant to the compliance of any obligation imposed on or accepted by the government under any agreement for the exchange of information or the assistance for the recovery of taxes with another country, territory, or jurisdiction. So there's relatively unlikely to ever, under that type of provision, be a mismatch between the domestic powers and what's being requested. But bear in mind that that is something that always needs to be taken into account. So moving on, somewhat swiftly, I hope, in Article 5, sorry, my screens have got all confused, bear with me. Oh, that's it. Article 5.5, this goes to the internal requirements for the requesting party. So this is what, say, the UK has to do so that it can make a proper request to Gibraltar. And so what they have to provide is the following to demonstrate foreseeable relevance: the identity of the person under examination, a state of the information sought, including its nature and the form in which the applicant party wishes to receive the information, the tax purposes for which the information is sought, the grounds for believing that the information requested is held in the requested party or is in the possession or control of a person within the jurisdiction of the requested party, to the extent known, the name and address of any person believed to be in possession of the requested information. The statement that the applicant party has pursued all means available in its own territory to obtain the information, except those that would give rise to the disproportionate difficulty. And I've got Graham again.
So you said that it was difficult to get the underlying information. That's the letter that you were talking about, right?
Yes, so this is the letter that comes from the, say, let's talk about a UK to Gibraltar one, because that's easy. That's the letter that would come from HMRC to your comptroller.
And that would look pretty similar whether it came under the tier or the DTT, right?
It would, yes, but it may need to refer to slightly different domestic powers. But yes, it should look similar. And it should. Is now the time to pull up our example?
Yes, I have it here. If you can, I haven't just interfered with the sharing, have I?
No, but I can't see anything different either.
Okay, hold on a second. I have it here in redacted form, but of course I pressed refresh when I shouldn't have done. I should have opened it. Sorry about this, guys. It's this sort of top level work that people come for, right?
Absolutely. Look, we're not information technology technicians, are we?
No, as I am proving. Okay, so I'm going to stop. I'm going to do a new share.
I think you're going to have to stop and reshare. Ah, perfect. And now,
okay, so you took me through that, and you can control it, can't you? So go ahead.
Can I? No. Oh, yes, I can. Is that me doing that, or is that's me? Okay,
that's you.
I'm impatient. So what you will get is something like this, and you can see this one is actually one under the DTA, not under the tier, but again, it will look similar. And so it will set out at the top these things. The taxpayer. Now, in terms of identifying the taxpayer, that doesn't necessarily have to be by name, and it can be to a group or class of taxpayers. So, for example, one that you might see would be beneficiaries of the X trust. That would be an acceptable identification. Then you obviously wouldn't get the address or the date of birth. You might be asked, they might specify an entity, as they have done here, and they might specify tax periods. So then you just get the introduction. This is with reference to a request received from from HMRC under Article 25. They then set out who's asking, that's HMRC, the period that it's for. Interestingly here, they say information is also sought in relation to earlier periods dating back to X, since this historical information is relevant to the period under inquiry referred to above. Now, in these circumstances, I would like to have an explanation of why that earlier information is relevant. I think this letter would be better. I'm not saying it doesn't comply, but this letter would certainly be better if that were the case. And that's my first question. That's the first sort of question mark this raises for me. So we then get the legal basis, sorry. And it just sets out the relevant legal provisions. I'm not sure that we need to go through that, but you should check that in the individual case. Is this relevant? Have they got it right? So you then get the scope of information, and this is where the foreseeable relevance test is going to be of primary importance. So obviously, unfortunately, most of this is redacted because it's identifying, so we can't do anything about that. But you can see they're setting out, I think, a little bit there about what the individual does, how they've done it. And they then say HMRC investigators believe that income is being generated through this arrangement that should be taxable in the UK. Now, again, without the information in question, it's a little difficult to know. But what you would be looking for here is it foreseeably relevant that that information is, the information requested is relevant to determining whether or not income is being generated through the arrangement. And of course, what you might well need there is English law advice, because you aren't necessarily going to know if the information requested is at all relevant to the tax in question. I mean, on some occasions, you will be able to infer that quite easily, but in other occasions, that's going to be very difficult, particularly if it's a highly esoteric point of law. One of the particular issues that arises that I see is you quite often get information requests in relation to poorly run pension schemes. They've been used in that context quite a lot by HMRC, and the legislation can be fiercely difficult to understand in that area. And so you will need to consider whether or not you need foreign law advice at that point. So if we keep going down, so.
Can I ask a question?
Of course you can. Yes, please do, David.
Thank you. Okay. So just regarding the process of collecting UK tax, if we take a case of a trust beneficiary, would it not be the case that the HMRC would find it easier, or would have to, in the first instance, write to that UK taxpayer? And so therefore, they would know about it before a TR request was issued.
That might be the case.
Or is there cases where these TR letters are sent without the UK taxpayer being aware?
Yes, that's a really good question, David. So the vast majority of the time, you're absolutely right to know. There are two circumstances which can arise where they won't know. The first is where the identity of the taxpayer isn't known. So the example that I gave, if they know there's a trust, but they don't know who the beneficiaries are, one of the first questions is going to be, who are the beneficiaries of this trust? And are they UK resident? So that may well be an example. The more concerning example is where, say again, and I'm only using the UK as an example because it's easy, HMRC don't want the taxpayer alerted, and then they may be able to use a third-party information request under the tier. And this happened under the Norway-Jersey tier in a case called Larsen, and Larsen generated a great number of other cases, some of which are confusingly called VOLAW, because the trustees were told they couldn't disclose the existence of the request to the taxpayer. And that generated a lot of case law because it put VOLAW, the fiduciary, in a really difficult position. So yes, that is an excellent question. The majority of the time they will know. On occasion, they may not. If they don't know, you will need to check very carefully whether or not there is any requirement on you, or any purported requirement on you, not to tell them. And in those circumstances, I would definitely take advice, because it gets very messy. I hope that answers the question.
Yeah, thank you.
No worries. So then we get sort of we get the some of the more formal stuff at 6. And then at 7, we just get a reference on. 8, again, that's very brief. I would be interested in maybe knowing a little bit more there. And then you can see at 11, that is the alleged detail of what's required. And we can't go into any more detail than that. But you want to be checking when you're looking at that, what you should have in the forefront of your mind is foreseeable relevance. Is this foreseeably relevant? And just to go back to what the CJEU said, the authority must have been enabled to satisfy itself that the information sought is not devoid of any foreseeable relevance having regard to the identity of the taxpayer concerned, of any third party asked to provide the information and the requirements of the tax investigation concerned. So that's
can I just stop there for a second? So the test there seems to be that it's devoid of foreseeable relevance, right? That's quite, it's.
I'm afraid so. This is what
devoid is not helpful there for somebody who's trying to resist, right?
I think the test as formulated by Wathalet was far better, but the CJEU have gone with, I think they were trying to make it a bit broader and they've really just made it fuzzier, which is usually the case, isn't it? Yeah,
so, okay. Right, do you want me to put the PowerPoint back on?
Yes, please, if you wouldn't mind. Oh, I can see everyone. That's exciting.
It is, isn't it? So now I've completely paralysed myself because I don't know what to do. There you go. There you go.
Lovely. And so that was, I think it's probably time to move on to the next slide. We're going to go. Oh, hang on. Okay. Sorry, I'm just getting control back of the slides. Thanks, Graham.
As ever in control, Harriet.
Would we want it any other way? So, as we've said, checking that the formal requirements have been complied with can be challenging. And you should also make yourself aware of the case law internationally. As I've said, there's a lot from Jersey, which went right to the Supreme Court in the UK. There's a fair bit from Guernsey. BVI and Cayman have had their fair share of it. So it's worth knowing that there is case law out there, albeit from a different jurisdiction, but it's on the exact same model type tier. So it's going to be relevant. Now, while it's challenging to make a request for the underlying document from the foreign jurisdiction, so the document in which they request the information from Gibraltar, doesn't mean that you shouldn't, and it may well be that that you can distinguish your case, but you've got to do it on a case-by-case basis. So I think when I'm talking about tier requests, the thing that I always think is most important is that you don't just do it by rote and go, oh, well, the government said we've got to give them something, we'll just give them it, because you could get yourself in real difficulties that way. So as you can see from the slide on the screen at the moment, there's then a mechanism as between the parties to go back and say, well, we need more time, or we need more information from you before we can do anything. That's fairly anodyne, but just bear it in mind, because you may be able to use it. You may be able to say, well, we need to know this is foreseeably relevant. We don't think you can say it's foreseeably relevant, so go and ask them for more information. So you can buy yourself time. So that's all I'd say really about Article 6. But what we have here is a flow chart of the process. So this first slide is the flow chart of the process from one revenue authority to the other. And you can see here, if you look, so it all starts on the left, jurisdiction A asks jurisdiction B for info. And then we've got sort of two columns. The first one is for where jurisdiction B has the information. It then simply provides it to jurisdiction A. And you can see there that the taxpayer whoever who's provided the information previously gets no say in those circumstances. You will never even know that that information you have given to Gibraltar Revenue Authority has then gone on to another jurisdiction. Now, there's not a lot you can do about that, but I do have some concerns as to whether or not this is rights compliant. And I'm thinking Article 1, Protocol 1, Article 6, Article 8, and Article 14 of the European Convention on Human Rights. But there, a bit like, as I said, with spontaneous exchange at the outset, there's not a lot you can do about it because you're not going to know. Now, the next diagram, which I hope is probably the more useful one, come on, Brown, there we go, it shows the process where there is a third-party information request. So the previous slide, we've got to the end of the third column and Gibraltar has asked you for some information. So you get your information notice and you have to consider the information request. Now, we've talked about foreseeable relevance, but the other things you're going to want to consider are set out below. So does the requested information assist in the administration or enforcement which discriminates against non-nationals of the requesting jurisdiction? This is quite technical. This goes to the prohibition of discrimination both in the DTA and in the tiers. So you're probably going to want legal advice there. That's going to cover two things. First, it's going to cover whether or not you have whether or not you have a whether or not the foreign law is discriminatory, and then possibly domestic law advice, Gibraltar law advice on whether it's assisting in that the administration or enforcement of that law. Might be difficult. You may not be able to carry out that analysis, but be aware that that is a basis for challenging a request. Secondly, and this is where you do need foreign law advice, could the jurisdiction requesting the information have obtained the information under its own laws for the purposes of the administration or enforcement of its own tax laws? Because this isn't a way for tax authorities to be lazy. If they can get it themselves, they need to get on with it. And so that is another reason for refusing a request. And then, does the requested information disclose any trade, business, industrial, commercial, or professional secret or trade process? What I would say about this is I have never, ever seen a case or in my practice that has resulted in someone saying, oh yeah, actually, do you know what? There is a trade secret. Don't worry about it. This is very unlikely to happen, but just if you have that odd case where someone's about to get a patent for cold fusion, then it's good to know about it. And then finally, and this is something you should always be asking yourself before you provide any sort of document or information to any other living human being, if you provide the information, is somebody being required to waive legal professional privilege? So if it's a communication between somebody and the lawyer, very broadly speaking, or if it's something to do with court proceedings, you need to think about whether or not you can send it, because if it's legally privileged, you don't need to. There's a carve out for that. So those are the more pertinent things that you need to consider after you've considered the formal requirements that we've discussed and foreseeable relevance. And again, sadly, it is the CJEU foreseeable relevance, not the Advocate General Wetherlett position. So, litigating tier requests. Ultimately, the final line of protection is, if you say all this and they say, no, we still need the information, you have a process under which you can challenge that in the courts. And the way that you challenge that is essentially you will have to judicially review the decision by the Gibraltar Authority to make the request. And that is when you can bring all of these points. So before a judge, I know nobody wants to bring them before a judge, but this is ultimately where you may end up if you feel that you have no option other than to say, no, we can't provide information under this notice. So that is the point that you'll be looking at. So the important things to remember, you'll be on judicial review time limits, which are shorter, and you'll be restricted on the judicial review remedies and arguments that you can make. So effectively, you're going to be looking for something like it's an abusive process, it's irrational, it's manifestly unfair, it's a breach of a legitimate expectation, it's a breach of a human right. Those are the key sort of arguments that you're going to be looking at in order to take this to the courts. As we've already alluded to when I mentioned the cases of Vowlaw and Larson.
Oh, that's me. Sorry.
Don't worry. When, as I alluded to when I was discussing Vowlaw and Larson, you may struggle to get information from the requesting authority. And one thing that has been closely guarded by the courts has been the request letter from the foreign jurisdiction. Now, if you had a lot of money to throw at this, what you could do, which might be quite fun, would be to run parallel judicial review proceedings in both jurisdictions, one challenging the decision to send the request letter and one challenging the decision to honour the request, if that makes sense. But yes, I think you have to have a certain sort of sense of humour to think that would be fun. Evidently, I do have it, but it's obviously not ideal for a client.
So just to be clear, Harriet, so because this is Gibraltar, so judicial reviews are rare, like hen's teeth. The more likely route would be a letter back to the commissioner saying, we think X, Y, and Z is not compliant. Go away and think about it again.
Yes. Oh, and that would always be your first port of call. Always. Absolutely. Yeah. You write back and you say, we don't think this is foreseeably relevant. We don't think that you've complied with requirement Y. We don't think the taxpayer is sufficiently well identified.
Yeah, so I don't think we're giving anything away. That we've done one like that where we push back and say revised and much more compliant and restricted request, didn't we?
Yes, that was it. We did. Obviously, the request did come back, but we got it massively shrunk down as to what they were requesting, I think, didn't we?
Yeah, I mean, the original request was slightly mad.
Yeah, and the original request, it was formally and substantively defective, is perhaps how I would describe it.
That's the fella. But just so that everybody knows, the commissioner is open to looking again if you go with a substantive.
Absolutely, and I didn't mean
he's not unreasonable about it.
I didn't mean to imply otherwise. Notwithstanding, you know, if you fancy having a pop, making some Gibraltar legal history with regards to judicial review and information notices.
Gibraltarian, not Gibraltar. You do that all the time. How many times have I told you that?
I'm incredibly sorry. If you would like to make legal history in Gibraltar, that will stop me doing it. This is your method. This is your method, and I accept that they wouldn't. And then we've just got there some of the stuff we've already mentioned, that your particular grounds are data protection, potentially. Schrems 2 is very relevant there. Human rights and procedural irregularity. Legitimate expectation might come up. And I've gone through what I think are the practical considerations. So where are we after this? Example request. We've looked through our example request, and I think the thing to note is, as Graham said, you can go back on any of this to the comptroller, and I think what we've also found, isn't it, that he's quite reasonable as to extending time.
He understands that things need to be gathered together. Yeah. He's never, in my experience, he's never rejected a request for a reasonable extension.
So I think you need to get moving on things. Asking for an extension 15 or 10 days before the time limit expires rather than 2 hours before it does is probably a good idea. But compared to a lot of the other jurisdictions I work with, Gibraltar, your revenue authorities do take a very reasonable approach. So you have. I would also
say from a Gibraltar perspective that it is best. I know he'll probably go mental if he hears me say this, but it would be best to deal with the commissioner rather than an inbox. Everybody in Gibraltar, everybody on this call from Gibraltar knows what I mean. If you can email the commissioner direct, it will be dealt with in a more speedy fashion than if it just goes into a info@type thing.
do you know what? I think that's probably true of most things. If I can put it that way.
Yeah, but I don't want to drown him in
paper
responses.
So just on there under example request, I've just set out the section 6A that I mentioned earlier. That's from your Income Tax Act, and that just tells you sort of the domestic process. So a brief word on trustees. And trustees are perhaps particularly vulnerable to receiving information requests for the reasons that we've already said. And they're also in a particularly difficult position because they have a number of duties to consider. So you've got, as we've mentioned, confidentiality, fiduciary duties, duties under the Gibraltar law with regard to disclosing information, and duties sought to be imposed upon them by foreign law. And I entirely blame my typo there on Rebecca, who didn't turn up and can't defend herself. So again, this is something where you may well want to consider taking legal advice, just because there may be a much broader spectrum, and it's so difficult to bring those two things together yourself. And so even though it's difficult for the lawyers to bring it together, at least you can access their indemnity, their professional indemnity insurance, if they give you advice that turns out to be wrong. So, you know, but it is a very difficult, trustees, fiduciaries generally, you're in a very slippery position with these, because you've got the force on the one hand of all of the international law and the Revenue Authority, and then trying to protect and help your poor clients on the other hand. So that sort of, we note that. Now, this says UK tax consequences of tier information. I'm going to talk very briefly about two things. One is the penalties under Gibraltar law, and you find those in, again, your Income Tax Act, and it is 65E, I think I said. It's
G.
Oh, is it G? Yeah, it might be G, 65G. And that tells you that a person who has failed to deliver a return, a person who has failed to provide to the Commissioner or any person authorised by him any information or document required in accordance with Section 6C is liable to a penalty of 500, and that's £500. So it might seem that it's not particularly, it's not a particularly good situation. Sorry, it's not a particularly bad situation. You might be able to wear that. However, I suspect that what is then going to come into play is section 65E and 65F, which is failure to comply with requirements of a notice and penalties where no penalty is specifically provided for by this Act. And so 65E, which is the penalty where there's no specific provision, in my view, what they might say is, we'll give you your £500 penalty for non-compliance, and then there's no provision for continued non-compliance, so you're in 65E, and that is a bit more a bit more concerning. And then 65F, that gets quite heavy. That gets quite heavy. We're into criminal liabilities there, really.
I think there would also be obviously within the boundaries of confidentiality and knowledge, but I think there would also be regulatory issues on fiduciaries. Absolutely.
And so then, just to mention very briefly, where you have a UK taxpayer, you need to be aware that by providing information, you may well be exposing them, and you may have to, but you may well be exposing them to quite significant penalties. Now, the UK has what it calls an offshore penalty regime, and it's got two that are particularly relevant at the minute. One is just the simple offshore penalty regime, and this applies where there's some offshore elements, so it's pretty likely to apply if you're involved. And what that will say, and what happens under that is, while the maximum penalty in most cases in the UK for this just a domestic matter is 100% of the tax loss, the potential lost revenue, it can be up to 300% where there's an offshore entity involved. And the other one is the failure to correct penalties. And this is where, before automatic information exchange came in, you had this window in which you could declare offshore irregularities. Now that window's closed, irregularities relating to the period prior to that weren't corrected now carry a basic penalty of 200% of the potential lost revenue. So the reason that I mention UK tax consequences is because you need to think very carefully, particularly in the context of rights to do with peaceful enjoyment of property, of the consequences of giving that information and whether or not that gives rise to any ground of review. And that is all I have for you. I think we have got possibly 2 minutes for any more questions, but thank you for listening. No, Graham says no.
No, we've got more time for questions.
Well, I'm in court in half an hour, so.
Oh, you're in court in half an hour. Okay, so we don't.
But what I would say is you all have my email address on the slides, and you're very welcome to write to me if you have a question that doesn't get answered.
So if anybody has any questions, please just put their hand up, or however that works. Feel free. If anybody wants to talk to me rather than to Harriet, that feel free. You know where I am. And people are saying thank you.
That's very kind. And it's been an absolute pleasure. And I have to say, I am extremely honoured to have been your inaugural speaker.
Yeah. Okay, guys. So hopefully we can do this again. We will be. GATA is committed to 4 open sessions a year at least, and we will be. There's a notice that's gone out that everybody should have had. We're talking about various things over the next 3 quarters of the year. Thank you very much for attending. I don't want to detain Harriet any longer if there are no questions. So please feel free, email me, email Harriet. The video will go up on a YouTube channel, and the slides will be circulated to everybody that attended. Thank you very much.